Well, there are very few cases anymore that actually get to trial. Maybe 2% of cases that are filed with the court actually get to a trial, where you're putting on your case on behalf of your client in front of a judge and a jury, or a judge or a jury. But there are a bunch of steps between the time you file your complaint, your lawsuit, and the time it gets to a jury where you're going to be in court. Motion practice, that's an example. And by that, it's all kinds of procedural filings that get you in front of a judge on your case. Motions to compel certain discovery. Motions maybe to dismiss your case. Motions for what's called summary judgment, which is after you take all of the discovery, depositions, written material submissions, questions, or what's called interrogatories, that the defense wants to claim, well, with all that stuff in mind, there still isn't enough to get to a jury. Those things you've got to argue before a judge, both in written and very often verbally to the court. So getting into court frequently is a must. If you really want to hire someone that knows what they're doing, that's a critical thing to know. Are you getting into the courtroom? Do you argue these things frequently? Or are you just sitting behind a computer or at your desk and don't get out into the courtroom much? Because courtroom practice is very important and very commonplace in our field.